Highness's letter dated 26th October has been delivered to me by VP Menon. In the special circumstances mentioned by Your Highness, my government have decided to accept the accession of Kashmir state to the Dominion of India, consistently with their policy that in the case of any state where the issue of accession has been the subject of dispute, the question of accession should be decided in accordance with the wishes of the people of the state. It is my government's wish that as soon as law and order has been restored in Kashmir and a soil cleared of the invader, the question of the state's accession should be settled by a reference to the people. Meanwhile, in response to Your Highness's appeal for military aid, action has been taken today to send troops of the Indian Army to Kashmir to help your own forces to defend your territory and to protect the lives, property, and honor of your people. My government and I note with satisfaction that Your Highness has decided to invite Sheikh Abdullah to form an interim government to work with your Prime Minister. Then we go back to the list of dates.
Abdullah was not the Prime Minister.
PDA page 38, Malad.
38.
38. And Malad, I've already read to your Lordships, Malad, the acceptance, the letter of Mountbatten. So, Malad, we go to 23, 5th of March, 1948.
Want to go back to the list of dates and
Yes, Malad. We go back to the list of dates, PDF 38, Volume 1.
What page are you reading, Mr. Sim?
5th of March, Malad, that entry. Because I've already read, Malad, the 22nd of October letter of Lord Mountbatten. On the 5th of March, my Lord has that. Volume 1, PDF page 38. Well, the 5th of March, 1948.
5th of March, 48.
Yeah, it's item 23. The ruler, you also have that? The ruler, Maharaja. I'm sorry.
1 minute, please.
Volume 2.
Volume 1, same list of dates that I was reading.
Some cases it's volume 2, some.
Written submissions, compilation, volume 2. That's correct. That's correct.
Written submission.
Yes, yes. WS volume 2.
Serial number 28.
PDF 38, WS volume 2. Yes. 5th of March 1948, the ruler Maharaja Hari Singh issued a proclamation under which a popular interim government was established in the state of Jammu and Kashmir, pending the framing of a constitution for the state. The proclamation inter alia. Well, it is better we read the whole proclamation. This is at volume 6, PDF page 242. Right. That's volume 6, PDF page 242.
Volume 6.
42. Says Millets, if your lordship has it. My lord Justice Surikant has it.
Volume 2?
242, Millets, volume 6, PDF page 242. Running page is 1291.
What? Volume 6?
Volume 6.
The time. Yes, Maharaja on the 5th of March 1948. That's the one.
1291.
Running page 1291. That's correct. That's correct. Well, we have to show PDF, Mullahs, otherwise it becomes difficult. Okay. In accordance with the tradition. Well, it's all of them correspond to the provisions of the Government of India Act.
Yes.
They were more there, but they were whittled down. That's all. But they do correspond. Just wanted to answer your lordship on that. In accordance with the traditions of my dynasty, I have from time to time provided for increasing association of my people with the administration of the state, with the object of realizing the goal of full responsible government at as early a date as possible, and in pursuance of that object have, by the Jammu and Kashmir Constitution Act 1996, established a constitutional government with a council of ministers, a legislature with a majority, that's the Praja Sabha, with a majority of elected members, and an independent judiciary. I have noted with gratification and pride the progress so far made and the legitimate desire of my people for the immediate establishment of a fully democratic constitution based on adult franchise with a hereditary ruler from my dynasty as the constitutional head of an executive responsible to the legislature. I've already appointed the popular leader of my people, Sheikh Mohammed Abdullah, as the head of the emergency administration. It is now my desire to replace the emergency administration by a popular interim government and to provide for its powers, duties, and functions, pending the formation of a fully democratic constitution. I accordingly hereby ordain as follows. My council of ministers shall consist of the Prime Minister and such other ministers as may be appointed on the advice of the Prime Minister. I am by royal warrant appointed Sheikh Abdullah as the Prime Minister with effect from today. The Prime Minister and the other ministers shall function as a cabinet and act on the principle of joint responsibility. Divan appointed by me shall also be a member of the cabinet. I take this opportunity of giving once again a solemn assurance that all sections of my people will have opportunities of service, both civil and military, solely on the basis of their merit and irrespective of creed and community. My Council of Ministers shall take appropriate steps as soon as restoration of normal conditions has been completed to convene a National Assembly based upon adult franchise, suffrage, having due regard to the principle that the number of representatives from each voting area should, as far as practicable, be proportional to the population of that area. In a way, he was adopting the principles that was adopted by us. The Constitution to be framed by the National Assembly shall provide adequate safeguards for the minorities and contain appropriate provisions guaranteeing the freedom of conscience, freedom of speech, and freedom of assembly. The National Assembly, as soon as the work of framing the new Constitution is completed, submit it through the Council of Ministers for my acceptance. In conclusion, I repeat and hope that the formation of a popular interim government and the inauguration in the near future of a fully democratic constitution will ensure the contentment, happiness, and moral and material advancement of the people. So go back to volume 2. Written submissions compilation, volume 2, PDF page 38 again. So in 1949, item 24 was there. Volume 2, PDF page 38. Mullahs, in a football field when there is no play, Mullahs, that time has to be excluded.
There's always a play going around. And
I submit to that.
who would better know about plays than you, Mr. Sibul?
I submit to that.
So this time out, as we said.
Maharaja Hari Singh issued a proclamation delegating his powers and authority to Yuvraj Karan Singh, who would function as the ruler of the state. We don't have to go to that. Following his appointment as ruler, Karan Singh nominated 4 representatives from Jammu and Kashmir to the Constituent Assembly in India. But the Constituent Assembly actually was formed in 1951, right? This is our Constituent Assembly. Sorry. Now, December 1947 to September 49, princely states underwent a process of integration into the Indian Union by signing merger agreements or covenants of unionization. The state of Jammu and Kashmir was not a part of this process of integration. That's important. By the covenants of unionization, various princely states entered into covenants with each other to form single units. For example, through a covenant, the princely states of Bhavnagar, your Lordship need not read it because this is the Lordships want. Junagadh, numerous others formed the United States of Saurashtra. Through a separate covenant, Gwalior, Indore, and 18 other princely states formed the Union State of Gwalior, Indore, and Malwa. Similar covenants led to the formation of Patiala, East Punjab States Union Pepsu, the United State of Rajasthan, and the United State of Travancore and Cochin. Between May 48 to September 49, the states of Saurashtra, Madhya Bharat, Pepsu, Matsya, Rajasthan, and Travancore and Cochin signed revised instruments of accession, which inter alia enlarged the powers of the Dominion legislature, permitting it to enact laws on all matters in lists 1 and 3, the Government of India Act 1935, and cancelled all previous instruments of accession entered into by rulers of princely states that had entered the covenants referred to above. Your Lordship may note that no revised instrument of accession was signed by the ruler of Jammu and Kashmir. Just note that fact for us. We're talking about December 47 to September 1949. Now, November 1949, through their respective rulers, Raj Pramukhs, the states of Saurashtra, Pepsu, Rajasthan, Madhya Bharat, Mysore, and Travancore and Cochin, amongst others, issues proclamations stating that the Constitution of India, shortly to be adopted by the Constituent Assembly, shall be the Constitution for the state, as for other parts of India, and shall be enforced as such in accordance with the tenor of its provisions. 25th of November 49, following the proclamations above, Rubraj Karan Singh issued a proclamation for the state of Jammu and Kashmir that the Constitution of India, shortly to be adopted by the Constituent Assembly of India, shall, insofar as applicable to the state of Jammu and Kashmir, govern the constitutional relationship between this state and the contemplated Union of India. We don't have to go through that document because it's all set out here. Then 26th of January 1915, in exercise of its constituent powers, the Constituent Assembly drafted the Constitution of India, which was adopted on November 26, 1949. The Constitution of India came into force on January 26, 50, repealing inter alia the Indian Independence Act, Government of India Act. The relationship between the Constitution and the state of Jammu and Kashmir was governed by Article 370 of the Constitution. It is evident that both the text of Article 370 and the negotiations that preceded its formulation, that Article 370 could not be changed unilaterally by Parliament. That's for that's of great significance. Then, Miller's 26th of January, 1950, same day, in exercise of powers under Article 370, sub-Article 1 of the Constitution, the following consultation with the government of Jammu and Kashmir, the President issued. This is the first Constitution application to Jammu and Kashmir, Order 1950. Under paragraph 2 of this order, matters in the first schedule to the order were declared to correspond to matters ceded to the Union of India through the instrument of accession, and subsequently the power of Parliament to make laws for Jammu and Kashmir was limited to such matters. Furthermore, paragraph 3 of the order declared that in addition to Articles 1 and 370 of the Constitution, provisions specified in the second schedule to the order would apply to the state of Jammu and Kashmir. It's important for us to go to this document, volume 3 of the documents, and it's PDF page 470. Sorry, page 4. Page 4, not 470. Page 4. Hold on. चलता ही नहीं है यार. Yes. This is the first constitutional order. Yes. Well, and kindly note this is on the same day. On the Republic Day that you signed this, do this. That's of great significance. In exercise of the powers conferred by Clause 1 of Article 370 of the Constitution of India, the President, in consultation with the government of the state of Jammu and Kashmir, is pledged to make the following. This order is so and so. For the purposes of subclause B1 of Clause 1 of Article 370 of the Constitution, the matters specified in the first schedule to this order, being matters in the Union list, are hereby declared to correspond to matters specified in the instrument of accession, governing the accession of the state of Jammu and Kashmir to the Union of India, as the matter with regard to which the Dominion legislature may make laws for the state, and accordingly the power of Parliament to make laws for the state shall be limited to the matters specified in the first schedule. In addition to the provisions of Article 1 and Article 370 of the Constitution, the only other provisions of the Constitution which shall apply in relation to the state of Jammu and Kashmir shall be those specified in the second schedule to the order, and shall so apply subject to the exceptions and modifications specified in the said schedule and to the modification that all references in the said provisions to the Raj Pramukh shall be construed as references to the Sadr-e Riyasat of Jammu and Kashmir. So, if you look at this first schedule, you will find defense, what I had indicated earlier in the instrument of accession. You will find naval military, then you find delimitation, naval arms, atomic energy, preventive detention, foreign affairs, diplomatic relations, United Nations, participation in international conferences, war and peace, foreign jurisdictions, admission into and emigration and expulsion from India, passports, pilgrimages, railways, piracies, maritime, all that your lordships will find. That's part of the first schedule. And then in the second schedule,
About
you will find-
96 items.
Sorry?
About 96 items.
Yes, 9. It's taken, yeah, they've taken the entries from the constitution.
It's less than the
Some are skipped, but they're not 96.
number of the
Come from, see, 31 to 41 is missing.
72.
Yes, there are several that are missing.
It's only the same Sheraton number.
That's correct, that's correct. That's all that there is.
At least one.
This one.
Correspond to the instrument of accession, actually,
Yes.
that defense, military.
No, that may not be correct, Mr. Sebu. The instrument of accession, the schedule which is short was far more restrictive. These are, you can say these are more elaborate.
No,
but
they
these do
relate
not
to the
correspond.
Constitution. I'm
They-
sorry.
They do not correspond. They're not.
No, correspond in the sense that they relate to defense. That, I'm not saying anything more than that. They relate to defense, they relate to external affairs. That's all that I'm saying, because the entries in the union list.
You read out the second schedule earlier at page 2, if I'm not mistaken, 196.
Correct. I'm not disputing that.
176.
When I said
176.
correspondent, I said the broad heads, that's all that I meant. Then say this schedule 2, is important. Article 72(1)(c), 72(3), 133, 134, 135.
Just one more clarification. This is by an order.
Yeah.
This is by an administrative order.
Yeah. Under Article 370.
370.
Yes, that's all. That's what I told your lordship in the initial stage. Constitution of India as applicable to the state of Jammu and Kashmir.
Correct.
That's all I meant. That's right, that's correct. Numbers, kindly see these exceptions are at 72(1)(c), 72(3), 133, 134, 135, 136, 138, 145, 151. Articles 80 and 81 shall apply subject to the modification that the representatives of the state in the Council of States and the House of the People respectively shall be chosen by the President in consultation with the government of the state. So that was the variation. Articles 54, 55 shall apply subject to the modifications that references therein to the elected members of both houses of parliament and to each elected member of either house of parliament shall be deemed to include respectively a reference to the representatives of the state in those houses and to each such representative. That the references to the elected members of the legislative assemblies of the state and to each such elected members shall be deemed to include respectively a reference to the members of the constituent assembly of the state and to each such member, and that the population of the state shall be deemed to be 44 lakhs and 10,000. But at the moment, it's about 14 million. 140 million, that's 14 crores. Now, Articles 149, 150 shall apply subject to the modification that the references therein the state shall be construed as not including state of Jammu and Kashmir. Then Article 246 shall apply subject to the provisions of paragraph 2 of this order, and clause 2 and 3 of Article 246 shall not apply in relation to the state. So no issue of repugnancy or anything like that. They can't pass laws because the residuary power of the state. Then 259 shall apply subject to the modifications that after the words until Parliament by law otherwise provides, the words and the concurrence of the state to such law has been obtained shall be deemed to be inserted. Article 266 shall apply only insofar as it relates to the Consolidated Fund of India and the Public Account of India. Article 282, 284 shall apply only insofar as they relate to the Union or the Public Account of India. 298, 299, 300 shall apply insofar as they relate to the Union. And 324 shall apply only insofar as it relates to elections to Parliament and to the office of the Vice President. So it doesn't apply to the elections in the state. 324, then 335, and then provisions of this part. 361 shall apply only as far as it relates to President. 364, 368 shall apply, provided further that no such amendment shall effect in relation to Jammu and Kashmir unless applied by order of the President under clause 1 of 370. So, Malas, the point that I'm making here is very simple, that the government of the day accepted the fact that our relationships with the Jammu and Kashmir government are on a separate footing. The provisions of the Constitution, unless made applicable through a presidential order and agreed to by the government, shall. So that will come to later. And the distribution of revenues, Malas, comes, and that we are not really concerned with at the moment. Now kindly come back to volume 2, Malas, of the written submissions, volume 2, page 41. That's what I'll be shown to. Page 41.
Constitution.
So the assumption is that if the President passes a notification for the application of any law to the state of Jammu and Kashmir, he has to seek concurrence. He cannot do it without concurrence. Consultation. Yeah. So it was a collaborative relationship in a sense. There was a constant dialogue going on. This is what we wish to do, and let's consult the state agrees, which is why most of the laws were made applicable. There was hardly any law that was left. In a sense, they were incorporated separately in the Constitution of India in its application to the state of Jammu and Kashmir orders.
What happened to currency, for instance?
Currency, Malaj, was the Sarveri Riyasat, as your lordship knows, Malaj.
Currency.
Currency. No, currency was Indian currency.
No, because, if you see currency in the Constitution is governed by entry 36 of list 1.
Yes.
But there's no reference to entry 36 of list 1 in the adaptation order.
But it will come later, Malaj. There were adaptation orders, subsequent adaptation orders. I'll come to that. I'll show that, your lordship. Because several, this comes in 1954, we have another adaptation order. There are several, give me on the list of several adaptations. We got a list by your lordship.
So were the subjects broadened by the subsequent adaptation order?
Of course, Malaj. Of course. They were broadened, Malaj. Every state they were broadened. We have an order of 52, we have an order of 54, we have an order of 71, an order of 74. Because the powers were extended, Malaj, and the state, Malaj, after consultation it was done. The state was ad idem with the union, Malaj. I mean, the state itself in its constitution says that we are integrated into India. There was no question. The Constitution of Jammu and Kashmir itself says that we are an integral part of India. So where's the question? The only thing is that there's a unique structural system in place, a constitutional structure which was in place, which suddenly, Malaj, on the 6th of August was done away with. And Malaj, with the greatest respect, I don't want to use that expression, suddenly, Malaj, in Parliament, it was said that we are doing this at 11 o'clock. Nobody knew about it. There was no consultation of any sort. which was, Malas, as I said, the governor of the state and parliament, and of course the powers that be, they decided to do this one fine morning and tossed it out. So, Malas, page 41. The Government of India published its white paper on Indian states clarifying the nature of Article 370. The effect of this provision, this is important, we're talking about 1950 itself. The effect of this provision is that the state of Jammu and Kashmir continues to be a part of India. Nobody disputes it. Nobody ever disputed it. It is a unit of the Indian Union. And the Union Parliament will have jurisdiction to make laws for the state on matters specified either in the instrument of accession or by later additions with the concurrence of the government of the state. My lords asked me that question. Steps will be taken for the purpose of convening a constituent assembly. The Lordship knows, Malas, this is very important. At that time, when, Malas, we became a republic, 370 was there. And 370 mentions the Constituent Assembly. But the Constituent Assembly had not yet been convened in the state of Jammu and Kashmir. That was convened in 1951, December. Point is that there was this understanding between the Government of India and the state that we will have a Constituent Assembly which will determine the future course of action. Determine whether or not, Malas, in fact, 370 should be abrogated at all or not. That decision was with the Constituent Assembly, which is why it is called a temporary provision, not for any other reason. It's in that chapter of the Constitution. So this whole argument that this temporary provision was 370 was temporary, no. It was temporary because between 1951...
Mr. Sehbul, what is the date of this white paper?
50, 90, I'll give you...
No, you're not given the date.
I'm sorry, it's at page 121, just see the date. We'll just give it to you in a minute. I'll give it to your lordships, just. So on the 1st of May 1951 now, Yuvraj Karan Singh issued a proclamation directing the establishment of an elected Constituent Assembly. March 1950, I'll give the exact date.
Okay.
It is March 1950. Huh? Can't be.
It cannot be 5th July 48.
It can't be. We'll give the date, Malas. I thought it was March.
Article 370 wouldn't have been then.
But in any case, Malas, the idea is that it's prior to 1951. That's the whole point. Whatever the date is, Malas, it's prior to 1951. In other words, the Constitution envisaged a Constituent Assembly which was to decide as to what would be the fate of Jammu and Kashmir. 15th March 1950 is what I'm told. Huh?
15th March.
Anyway, let's not get into this. We'll give it. Why amongst ourselves in the day? It's prior to 1950.
Well, you can verify it and then give a date.
I'll give it. Yeah, give it to your lordships. 1-5. Sorry. $254 now. they didn't correspond, the 1950, the order didn't correspond, but as if you look at the 50 order, it says para 2, for the purposes of subclause B1 and clause 1 of 370, matters specified in the first schedule to this order, being matters in the union list, are hereby declared to correspond to matters specified in the instrument of accession. Just wanted to mention that. Para 2 itself says. So, my lords, we all have done. On the 1st of May 1951, Karan Singh issued a proclamation directing establishment of an elected constituent assembly to draft a constitution for the state of Jammu and Kashmir. Then 20th of March 1952, under Article 370, Sub-Article 1 of the Constitution, and following consultation with the government of Jammu and Kashmir, the President issued the Constitution.
Just one.
I'm going to better read it now. Also, the same thing. The same article. 370 for a minute, but they'll give your lordship some.
No, just continue. Where you want, whichever way you want.
No, but let's read 370 because the context will be clear. That's how it was understood at that point in time. We're talking about January 26, 1950. Well, let's, my lords, have the Constitution.
Yes.
It says, my lords, notwithstanding anything in this Constitution, the provisions of Article 238 shall not apply in relation to the state of Jammu and Kashmir. Now, 238, my lords, Part A, Part B, Part C, Part D states. That's what 238 was, my lords. So it couldn't apply. It's neither, the Jammu and Kashmir didn't fall into that category. Sui generis. The power of Parliament to make laws for the said state shall be limited to those matters in the union list and the concurrent list, which in consultation with the government of the state are declared by the President to correspond to matters specified in the instrument of accession, governing the accession of the state to the Dominion of India, as the matters with respect to which the Dominion legislature may make laws for that state. And such other matters in the set lists as with the concurrence of the government of the state, the President may by order specify. So the items, whether it's communication, defense, foreign affairs in consultation, for all matters concurrence, for all other matters concurrence. Explanation. For the purposes of this article, the government of the state means the person for the time being recognized by the President as the Maharaja of Jammu and Kashmir, being acted on the advice of the Council of Ministers for the time being in office under the Maharaja's proclamation, dated 5th day of March 1948. This explanation was added later, Mothers, and I'll point that out to your lordship later. It was amended later, Mothers, this particular explanation. The provisions of Article 1 of this article shall apply in relation to that state. Such of the other provisions of this Constitution shall apply in relation to the state, subject to such exceptions and modifications as the President may by order specify, provided that no such order which relates to matters specified in the instrument of accession of the state referred to in paragraph 1 of subclause B shall be issued except in consultation with the government of the state, provided further that no such order which relates to matters other than those referred to in the last proceeding proviso shall be issued except with the concurrence of that government. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1, or in second proviso to subclause D of that clause be given before the Constituent Assembly for the purposes of framing the constitution of the state is convened, it shall be placed before such assembly for just decision as may be taken thereon. Notwithstanding anything in the foregoing provisions of this article, the President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify, provided that the recommendations of the Legislative Assembly of the state shall be necessary before the President issues a notification.
Constituent
Sorry,
Assembly.
the Constituent Assembly. This now is replaced by the Legislative Assembly. The Constituent Assembly. So you had to have a recommendation of the Constituent Assembly before you could efface 370. That's what the Constitution makers themselves thought in 1950. And that operated till 6th of August. How could it change?
But how long would the tenure of the Constituent Assembly of the state be?
7 years. 6
Sorry?
years, Malas, 51 to 57.
So therefore, with the end of the 7 years,
Yeah.
the very institution of the Constituent Assembly of the state lapses, then there's no Constituent
Absolutely
Assembly
right.
left. But
Absolutely.
then what happens with the
But this is the
proviso?
point, Malas.
But then what happens with the proviso then?
This is exactly the point, Malas. This is exactly the point. Malas, the in between 51 and 57, the Constituent Assembly could take that decision.
But thereafter,
Thereafter, Malas, there's no question because they formed the, Malas, take the Constitution.
what happens after the Constituent Assembly has come to an end? Because no Constituent Assembly can have an indefinite life.
That's precisely the point, Malas. That is my point. The Constituent Assembly in India, when it drafted the Constitution, can't have a life after the Constitution is framed.
No, but equally, the proviso to clause 3 refers to the recommendation of the Constituent Assembly of the state.
Yes.
The substantive provision says that the President may by a notification declare that the article shall cease to be operative,
Yes.
right? Now, the only safeguard is that before the President does so, the recommendation of the Constituent Assembly of the state has to be taken.
Yes.
Now, what happens at a point of time where the Constituent Assembly of the state ceases to exist?
But that's the point. The President can't issue such a notification.
According to
No.
after 57, it can't be done at all.
No, after 57, it can't.
Then
What happens-
clause 3,
That's what the-
exactly.
that's
What
why
happens
it's for
to
the-
what temporary used in the
That is
article?
why the temporary provision.
No, but Mr.
Because,
Sibal,
Manas, this was,
one more fundamental issue, which is that notwithstanding the fact that the proviso ceases to operate, clause 3, the substantive part continues to hold the field.
no, it is dependent on the proviso.
No.
With respect, no, Malas, with respect, any proviso.
If the
Malas, it is
proviso, I mean, there are ways in which you can construe a proviso, but if the proviso ceases to operate by virtue of the fact that the tenure of the Constituent Assembly of the state has ceased to exist, surely the substantive part of 3 still continues to remain.
Kindly see the scheme of 370, Malas, with the greatest respect. Kindly see the scheme of 370. On the 4 items, Malas, that is defense, communications, external affairs and ancillary matters, Malas, the consultation of the state is necessary under 370. For all other matters, the concurrence of the state is necessary. So can you say you do away with the concurrence? And then the third thing is, if you want to abrogate 370, then or amend it, you have to get the recommendation of the Constituent Assembly.
So long
What
as
is
it
put
exists.
to me,
So long as it exists.
Marat, I'm sorry, Marat, this is the point, Marat. That's why I said initially, the Constituent Assembly, Marat, has served its term when a constitution is framed.
So in which case, then what happens is if your construction is right, 370, which is essentially a transitional provision, assumes the character of a permanent position
No, it is a
by,
transition.
by virtue of the fact that there is no Constituent Assembly of the state after 1957.
Absolutely, absolutely. It's a transitional provision between 1951 and 1957 when the Constituent Assembly could take that decision. Which was left to the people of Kashmir.
So according to you, after 57, sub-article 3 has become redundant.
Whereas Constituent Assembly, even in the context of Constitution of India, is redundant.
So there is
You
no,
can't revive a constituent assembly.
there is no method according to you
Yes.
by which either with consultation assembly or
Yes,
otherwise,
yes.
can 370 at all be abrogated?
Malas, the
Because
amendment that is made ultimately, they convert the legislature into a constituent
that's a
assembly.
different matter. I
No,
know
no, no, but that tells you their understanding. Please appreciate that. It's their understanding of the constitution.
No, Mr. Sibyl, there are two separate aspects. One is interpretation of clause 3 of Article 370 and the proviso to that.
Yes,
The second part is what the amendments have been made and how do you interpret.
yes. I can't hear your lordship. Yes.
One is interpretation of clause 3 to
Right,
Article
right,
370 has to be done independently of the amendments.
Right.
So your contention is the proviso specifically applies, and unless the proviso is resorted to, and it cannot be resorted to after 1957, clause 3 will not be applicable. That's your sum and substance.
Yes, absolutely. Absolutely. That's absolutely right, Mullah. That's absolutely right. Whereas, just as clause 2, 3 has worked itself out. Mullah, the point is, why was this clause put in 1950? What? Because in 1950, they said we'll have a constituent assembly. See the constituent assembly debates, it will be made clear.
51 to 50, sir.
No, but the fact is in 370, at that time the Constituent Assembly was not there. The whole purpose was. Yeah.
To accept your submission, we'll have to postulate that clause 3 becomes a sort of a constitutional article which falls into desuetude after 7 years.
Yes, absolutely. Because
How can that be?
Whereas I-
Clause 3 still continues to survive.
whereas
The limitation
Kindly
on
see
clause 3 may cease to operate.
kindly see 369. Continues, Mullah. Kindly see 369. Temporary powers to Parliament to make laws. That's the part. Part 21, Mullah.
See, 371 begins with a non-obstante clause. It
Yeah.
overrides the entirety of the constitution.
Absolutely, Mullah.
But
So does
clause
370.
3 contains a non-obstante clause which overrides clause 1 as well.
Yes.
So therefore, notwithstanding, because 371 makes special provisions in relation to the state of Jammu and Kashmir.
Correct.
But 373 has a non-obstante provision which overrides the non-obstante clause in clause 1.
For that period, Manoj, we are not disputing that. What your lordships is putting to me, there is a structure in place that was envisaged by the constitution in Manoj 1950. At that time, there was no constituent assembly. Why did they mention constituent assembly? Need not have mentioned it. Kindly can look at it from that point of view. What was the reason to mention constituent assembly in 370 when it was not even in place? Would have said government of Jammu and Kashmir. Why did the constitution makers, Manoj, include the term constituent assembly in 3? Because they knew that the constituent assembly will frame a
Actually,
constitution.
there was no limited, the acceptance of sovereignty of the Dominion of India was complete. They didn't say in the instrument of accession that we accept the sovereignty of the Union of India for some limited purposes. They accepted the sovereignty for all intents and purposes. That acceptance of sovereignty was complete, but they reserved certain rights to themselves over certain legislative subjects. So in that sense, the accession was complete. The acceptance of sovereignty was complete. Now, consistent with that, therefore, it said that in clause 3, that the Union of India would have, the President of India would have the right to abrogate Article 370.
Not
It
the Union of
conditioned
India.
that subject to
Not the
the
Union of
recommendation.
India, Malaj, on the
President.
recommendation of the Constituent Assembly. Not Union of India has no right to till that is recommended. The word is recommendation of the Constituent Assembly. Then they can exercise that right. That's how you interpret a proviso. You can't say that they have the right sovereign, forget the proviso, even the recommendation of the Constituent Assembly, because it doesn't exist. Then 368 2 proviso also goes, Malaj. Therefore, the reason is simple, Malaj. The genesis of it was the fact that in 370 itself, it was mentioned that the Constituent Assembly has a role to play in the abrogation of 370. Otherwise, if your lordship says it had no role to play, there was no need for 370 sub article 3. And let's look at the concurrence power. Even those powers were of no relevance thereafter because the constitution of Jammu and Kashmir was in place. There was no need for concurrence anymore. Because now you have a constitution of the Jammu and Kashmir. So that also became ocious. Have to see, Malad, the historical perspective in the context of which Jammu and Kashmir ultimately signed the instrument of accession. Nobody disputes whether they are integrated into India, but subjected to a constitutional provision.
Therefore, the submission is that once the period stipulated in the proviso to clause 3 had come to an end,
Yes.
the power under clause 3 itself came to an end.
Because it's no longer alive. The Constituent Assembly, like in India, Malaj, can, for example, today, Malaj, there can't be a provision in the Constitution of India with reference to a Constituent Assembly, because the Constituent Assembly has worked itself out. It has formed the Constitution. Now, if it is decided that they would abrogate 370, the Constituent Assembly would have said, we abrogate 370. Which is why it was a temporary provision. Not because of the fact that under as a Union of India, it was deemed to be a temporary. How could it be?
Sorry, interrupting you at this stage. It does maybe just putting a question.
Sure.
I'm not. If one looks at Article 370, clause 1B,
1B, yes.
the power of the parliament to make laws for the state shall be limited to, it says, matter in the union list and the concurrent list in consultation with the government of the states are declared by the president to correspond to matters specified in the instrument of accession governing the accession of the state to the Dominion of India.
Right.
To such other matters in the list as with the concurrence of the state, government of the state, the president may, in the order may specify.
Yes.
Then explanation deals with what is meant by the concurrence of the state.
Right.
Then it says that provided that no such order, the first proviso, provided that no such order which relates to the matter specified in the instrument of accession of the state, referred to in paragraph 1 of subclause B, shall be issued except in consultation with the government of the state.
Correct.
Provided further that no such order which relates to matters other than those specified in the last preceding proviso shall be issued except with the concurrence of the government.
That's right.
So the second proviso talks about concurrence of the government.
Yes.
Now, if one looks at clause 2,
Yes.
it deals with a situation where the assembly or the government of the state is not there. It deals with the period when the constitutional assembly of the state was in existence, but the government or the elected assembly was not in existence. And therefore, the proviso to clause 3 will only be applicable as long as the government of the state or the assembly is not elected. Because election of the assembly will take place after the Constitutional Assembly of the Constitutional Assembly of that, of the state of Jammu and Kashmir enacts the Constitution.
Government was always in place from day
No,
one. Manoj.
no, maybe so.
Government is always in
Because
place from day one.
that appears to be the broad, outline of this, outline of Article 370. What Clause 2, when it refers to the Constitutional Assembly of the state, it is for the purpose of for framing the Constitution of the state, which shall be placed before the Assembly for such decision as may be taken thereon.
Correct?
So the Constitutional Assembly of the state makes the Constitution, frames the Constitution, it goes before the Constitution.
No, it can state in the Constitution that that the 370 is abrogated. What problems are there? It has the power. That's why there is a Constituent Assembly. It says, Malaj, notwithstanding anything in the foregoing provisions, kindly note that. Notwithstanding, Malaj, 37(1)(b)(1) and 37(2). Notwithstanding any of that. So, Malaj, you start the article by saying notwithstanding anything in this Constitution, and 3 starts with notwithstanding anything in the foregoing provisions. That is notwithstanding the opening part of the article also. There was a government, yes. Yes.
Assistant of Constituent Assembly of the state.
Yes.
If sub-article 3,
Yes.
according to you,
Yes.
has become non-existent, ceased to operative,
Yes.
then how the very temporary nature of Article 370 will survive?
That's why, because it's temporary, because the Constituent Assembly had not been framed, but at that point in time had not been constituted. In 1950, when this provision was added in the Constitution.
No, if sub-article 3 goes, then that means Article 370 can never be abrogated.
Yes, that's the whole point, Manoj. That is our case.
Then how it is temporary?
It is temporary because when this article was framed, Manoj, there was no Constituent Assembly. It was the Constituent Assembly which could have taken the decision that we will abrogate 370 and merge completely with the Union of India like any other state.
Mr. Sibal, your contention, if I've understood you correctly, is that the temporary nature of 370 is correlatable to the
Life
Constituent
of the
Assembly
Constituent Assembly.
life.
That's my
And
argument.
in a way, subclause 3 becomes otious once the Constituent Assembly ceases to exist.
Correct.
This is your contention.
My contention.
From 51 to 57, it is temporary.
Your lordships of the Constituent Assembly, they say the same thing. Mr. Iyengar, they say the same thing, what I'm saying, Manoj.
I'm just trying to phrase it as I understand
I-
it. So
I-
I'm clear
The
that
lordships have understood it, and I also understand your lordships, what your lordships are thinking, Manoj. So I have to respond to that.
According to it is temporary between 51 to 57
That's correct.
and thereafter permanent.
The reason is simple, Manoj, all Constituent Assemblies are temporary. There is no permanence in a Constituent Assembly. So when you.
Role is limited to framing the constitution.
Yes. Therefore, Manoj, if it is temporary by its nature, which is why I started by saying this is a political exercise. That's why I, Manoj, started with that summation before your lordships. The formation of a Constituent Assembly is a political exercise to ensure that people within the territory of a particular region, their aspirations are taken into account to formulate a law and a constitution to ensure that those aspirations are met in future times to come. It's not a law-making exercise. Then they framed the constitution to take into account those aspirations. That's how our republic came into force. Because there was the 1935 Act, there was diversity. Well, let's kindly look at it historically. Let's not forget the law for the moment. Look at it historically. If you look at Europe, and the making of the nation states in Europe, how did that happen? It happened because there were large empires, the Austro-Hungarian Empire, Prussian Empire. And whereas those large empires had communities and within those empires, there were peoples of different